there is a concern about crucial witnesses who are in fear of recording their statements. The investigating team is still pursuing means to have them record their statements because they are in fear due to the seriousness of this offense and the public interest that it has elicited. And they are hopeful that in due course, these witnesses who are in fear will record their statements and cooperate with the police in investigations towards conclusion of these investigations. Hired for the respondents to undergo psychiatric assessment in case or subject to directions from the DPP. If they are found culpable for any offense, in particular this case, offense of murder or otherwise, they're supposed to undergo psychiatric assessment, which assessment requires them to be present to be escorted by the investigating team, has elicited huge public interest. The family of the deceased, which I believe are represented before this court, as well as the public, are awaiting to know what happened to the deceased person. That mandate falls on the DCI, represented in court, as well as the DPP. So we are, in the interest of justice, we are asking this court to grant the investigating team an additional 7 days, which period will be utilized to conclude investigations. Part of the days will be used to conclude investigation. Part of it will be used to peruse the file and give express directions on the action to be taken in the interest of justice in this matter.
There is actually no authority to extend time the way the authorities here are asking you to do. But Your Honor, you were sympathetic and granted them 7 days. Instead of them using those 7 days, they have come here to test your patience and asking you to regularize. They are keeping these people in custody for longer than required. Instead of utilizing that time efficiently, they come before you and request you very casually to give them 7 more days. And as I intimated before, they don't even tell you that your authority to give us these more 7 days is founded on these provisions of the law. Your Honor, it is inappropriate. It is unjust. And my friend here quotes public interest. Yes, this is a matter of public interest, but it is not in the public interest to have pretrial detention without cause and without reason. It is not in the interest of justice, Your Honor, to detain people at the pressure of investigating officers so that they can have their good time holding people in custody against the law. You know, this is a court of law. This is a law, Your Honor. This is a court that is bound to rule and decide matters on the law that is provided. Permit me, Your Honor, to simply refer back to the authorities that I had given. Your Honor, they had these 7 days and they have done a lot. So we must congratulate them, Your Honor, for doing so much, as they say. And if they have done that much, then let them charge our clients this afternoon so that we can apply for board. For matters of investigations, Your Honor, we do not have any problem. The investigating team, Your Honor, cannot be bound not to do their investigations until they know they have completed. But the adage of the High Court and the rulings of these authorities: do not arrest people unless you have completed investigations. Do not arrest people and then ask the court to give you time so that you keep them as the reluctant guests of state at your leisure as you go and do your own mundane things. taking all the time that you need. Forensic reports, Your Honor, do not have much to do with whether or not to charge. We always get those forensic reports in the course of the trial, and we deal with them. We deal with them. But that too cannot be used to justify the detention of our clients. There is in the affidavit averment about a certain John Mwikiria. Everybody is sorry about this deposition about John Mwikiria. But Your Honor, that fact of that gentleman can also not be used to justify an apparent illegality. It cannot be used. And at whatever time they complete investigations about him, if our clients will have been released, they will come back, they will arrest them. If our clients will have been charged and they get information about this gentleman, they always are free to amend their charges, to substitute their charges. Their arms, Your Honor, are completely unfettered. Provides a specific period. Can the Criminal Procedure Code, either by dint of Section 36 or any other provision, override the provisions of the Constitution? And I have resubmitted, Your Honor. The High Court has already provided this answer. The law does not allow extension of time. And if the court were to continue extending time against the constitutional mandate, then we'll be going outside in custody anymore. They have been held for long enough. They have cooperated with the authorities, and the defense on its part, as I have stated over and over and over, we do not wish to have the investigating team barred from doing their work. We are only seeking that our clients' rights be upheld by this court. Your Honor, an hour in any police station is literally a lifetime. The investigators, Mr. Wanjohi, my good friend, and Mr. Kamau, they are not suffering any prejudice. But these people, Your Honor, are suffering all the prejudice. These suspects, Your Honor, are suffering by having their rights to liberty curtailed without due cause. It is the Constitution that protects them, Your Honor. And the guardian of the Constitution, as of now, is Your Honor. I urge you, and I humbly do this, Your Honor, that you uphold their rights, that you refuse to deny them their rights any further, yes, Your Honor, and you make the appropriate orders. The Rotich decision, Your Honor, gives us an option.
The best thing here is to balance the rights of all persons concerned and to know on which side is the pendulum, on which side is the pendulum going to swing, so as to know who is going to be prejudiced. Be that as it may, a cardinal balance act will have to be performed. Yeah, I note that the accused persons, at least so far, as deponed in the affidavits of the investigating officer, they have been cooperating at length. Yeah. Again, I take it that it is only a period of 7 days that remains. Yeah. Therefore, the best way for the court to balance here in the scale is to give the accused person the option of bond, which I hereby do, of Kenya shillings 1 million with 2 sureties. The accused persons in the remaining 7 days to report to the investigating officer at 9 a.m. The orders herein will lapse at the end of the 7 days. That is how the elephant in the room has been dealt with. I also take refuge that in the 7 days that is remaining, the investigating officers will have been able to finish the investigations, because we are told They're divided into a team, each team pursuing a lead. That is the order.